Good morning, everyone. Thank you so much for logging on to join us for our final class in this three-part series. We are really excited to have a Fair Housing 301 for rental professionals available to you this morning, thanks to a very generous grant from the Michigan State Housing Development Authority, or MSHDA. My name is Liz Keegan. I'm the Director of Education and Outreach, and I'll be co-presenting this morning with Brianna Miranda, our Education and Outreach Coordinator, and making things run smoothly behind the scenes and answering all the questions and helping people get on this morning is Lindsay Owens, our other Education and Outreach Coordinator. There's Bree. She'll be swapping in and out with me as we go through a nice agenda full of information for you this morning. So just a highlight here, as usual, we will be taking attendance through our evaluation/survey. So we'll share that link towards the end of the class. Please note that each individual person must complete the survey in order to record your attendance. You should be able to fill it out multiple times. If you have any issues, let us know. We do want you to complete those by the end of the day tomorrow at 5 o'clock. It will close. So please make sure after the class today, you look in your browser windows, you grab the link from our chat, and we will send it out to those of you who attended as well. Please note you are muted and your cameras are off, so we cannot hear you or see you. Please use the chat if you need assistance. We also have a Q&A button that we'd like to have questions submitted through that feature of Zoom. The Q&A feature helps us track the questions and make sure we can get to them as we go through the training. We'll save some time at the end as best we can. If you have a very specific situation with a lot of details, we encourage you to email us with those questions and we'll do our best to assist you. We know sometimes there are lots of questions that have a lot of nuances. And if you've worked with us before and been on our trainings before, you know that we will ask you a lot of questions about your question in order to be helpful. So we do love to get questions. We are recording this session. We'll make it available on our YouTube channel. So all three of the Fair Housing 101, 201, and 301 videos will be up thanks to our MSHDA grant. And with that said, I think we will go ahead and get started. Couple disclaimers. We don't have attorneys on staff, and therefore we literally cannot give you any legal advice. So we are a private nonprofit. We don't have attorneys. So everything that we're providing, all the information and materials being shared today and being shared as handouts are for educational purposes only. And also just want to highlight, we train from a risk management perspective. So all of the information we're sharing today focuses on risk management strategies and best practices, and again, is not legal advice. Something else we want to highlight is that all information is current to the best of our knowledge, but it could change at any time. We do want to highlight that HUD guidance is being reviewed. A lot of it is being reviewed, and some of the guidance that we have traditionally used for this curricula has been withdrawn or is being reevaluated. So we are keeping an eye out for further guidance from HUD, and we will push that information out as soon as we can. So stay tuned to our website and to our social media pages to learn more. As we learn more, we will share that out. So this is our team. As I mentioned, I introduced everyone. We encourage you to check out our website, follow us on our Facebook and LinkedIn pages. And again, thanks to MSHDA for sponsoring this incredible training series. I know a few of you are asking for additional dates and upcoming trainings, and we are anxious to get those settled and published as well. But we are waiting on grant finalization to do that. So we will, as soon as we have it, we will let you all know. We are anxious to get a calendar up and running, and we'll push that out as soon as we have it. So we will talk about a very quick review of fair housing laws and protected classes. We'll do a deeper dive, a look at Michigan's new source of income protections in rental housing, and then we'll look at advertising, screening, applications and selections, occupancy, effective communication, protections for persons with disabilities under modifications and accommodations, and then share some tools and resources with you as well. So as I mentioned, we are a private nonprofit organization. We do not have attorneys. We cannot provide legal advice. However, fair housing is all we do, and it's all we've done for 45 years. So really proud of that history. Our mission is ensuring fair housing choice and equal access to housing opportunities for all. We do this through education and advocacy, which affirms the right of all people to choose where they live, free from illegal discrimination. So we kind of have a two-armed approach to our work. One is that we do conduct investigations of allegations that we receive, and we also provide education such as this to not only the industry, not only to all of you, but to home seekers and community members so that they know what their fair housing rights are as well. And we want to acknowledge that you may be here in your professional capacity, but these are all your fair housing rights and the rights of your family and friends and community members, your neighbors. We all have these fair housing rights. So it's a little bit of a dual role there. I saw lots of cities signing on this morning from across the state. That's so wonderful to see. We really appreciate, the high response. We had to start a wait list for this class, so thank you all for agreeing to watch in small groups and working with us to try to fit as many people as we could. We had well over 500 people interested, and that's just really wonderful to see. We do have other fair housing centers in the state. We have a Detroit area group. Southeast and Michigan is kind of the Ann Arbor, Ypsilanti area. Southwest Michigan is based out of Kalamazoo, and we are West Michigan based out of Grand Rapids. But here is a helpful map that Mishta put together to kind of illustrate the coverage of the fair housing centers across the state. There is a legal services group based out of Flint that does some fair housing as well. But we are the primary group that covers all of the counties in green. But we've also done a lot of work across the state in partnership with our other fair housing centers. So we're happy to connect you to your local group. And the benefit of knowing your local group is that there are local fair housing laws. So we always encourage you to make that connection as well. So quickly, what is fair housing? It's the right of individuals to obtain housing of their choice, free from discrimination based on all of the protected classes under federal, state, and local fair housing laws. So those layers of laws can create some gray areas and some confusion, although with some recent changes here in Michigan, a lot of our protections have come in alignment. And so we have a lot of similarities, which makes it a little bit easier, hopefully, for people to understand and utilize fair housing. The fair housing laws prohibit discrimination in any housing transaction, including rentals, sales, lending, and insurance. And we are very passionate about the work we do for many reasons, but one of the key reasons is that where we live directly impacts how we live. So being able to choose freely without experiencing discrimination is incredibly important. Where we live dictates access to schools, healthcare, jobs, transportation, green space, groceries, all the things that we need to run our daily lives successfully. And so freedom of choice is really important. So we've got a lot of polls for you today. So be prepared if you're watching as a group to discuss and vote together. And if you have any issues, let us know. But we've got, I think, about 20 some poll questions. So it's going to be a very interactive class today. And hopefully I can start us off with a successful launch of our very first poll, which is a matching question. So this is a tough one. Hopefully you've attended the other fair housing classes we've had, but we are asking you to to match which of the three protected classes is a federal protection, a state Michigan protection, or a local protection. And I see a lot of you are quick on the draw. So we'll give you about 30 seconds, maybe a little more because it is matching. And then we will end and share the results. And just a quick housekeeping note, the polls are really for interaction. They are not graded or required. And also another housekeeping note, if you haven't gotten the materials for today's training, you can find the link in the chat and they could be downloaded from our website. They will be available today, but after today, we will be taking them down because the information may become outdated. Sometimes the poll windows don't pop up, so you might want to check your taskbar along the bottom of your screen to see if it shows up as minimized. But we will have all of the poll questions on the screen in the PowerPoint, so you should be able to see them even if you can't see the poll box itself. So sorry about that. Zoom has made a lot of changes, and sometimes that it doesn't work well. So you can play along at home. Okay, so I'll give you another couple seconds here, but then I'm gonna end the poll and we will take a look at our results. This is kind of a fun feature that Zoom has so that you can see most of you said that race is federally protected, and that is correct. Um, And then we had marital status, which is a state protection. So a lot of you got that answer as well. And then weight is something that we do see in local fair housing ordinances. And that's typically because those fair housing ordinances cover not only housing, but employment and education and public accommodations law. So the civil rights laws tend to come as a bundle. And so those protections usually come into play in those other areas, but they are protected classes. So we want to make sure you know about that. So, all right. Great job there. So, as we have started to think about and look at, our group of protected classes has really grown. Across the United States, we have race, skin color, national origin, gender, religion, disability, and families with children as protected classes. Here in Michigan, we have marital status, age, with the exception of senior housing, which is 62 and older or 55 and older. Race now includes hairstyle and protective hair textures and protective hairstyles here in Michigan under the Crown Amendment that was put into place in 2023. We have sexual orientation and gender identity or expression that passed also and went into effect in 2024. And most recently, source of income protections in rental housing as well. So we'll talk a little bit more about that new series of protections. And then local laws depend. We have the cities on our website that have additional fair housing laws in our service area, but we're happy to help you do some of that homework. But I want to highlight, Ann Arbor, Detroit, Grand Rapids, Holland, Jackson, Kalamazoo, Kentwood, Lansing, Traverse City, and Wyoming are just a few of the over 40 cities in Michigan that have additional local fair housing protections. You can use these free code library links to look up different cities across the state. You can check with your local government or you can contact your local fair housing centers. Just a few ideas to figure out what other laws might apply based on where you are working. So especially if you move around in a metropolitan area, you want to make sure you're familiar that the laws may change based on crossing the road. So we really encourage that you make a list of your local protections paired with all of the state and federal protections and use that as a tool. I think that's the best fair housing best practice we have is know your protected classes, because the first thing you'll want to do is check who's protected when you have fair housing questions. It's the first thing that we do when we get a question. We say, okay, is there a law that applies here? Who is protected? So that's a great best practice. As I mentioned, we have the new source of income protections that have passed. There was a 5-bill package that together amended 2 different state laws. Our Elliott Larson Civil Rights Law, which is where our fair housing state protections live. And then the Landlord Tenant Act was changed so that they match across the board. And these laws went into effect earlier this year on April 2nd. So Michigan source of income protections defines what it means by different sources of income. So it covers benefits or subsidy programs like housing or public assistance, housing choice vouchers, veterans benefits like the VASH vouchers, VASH vouchers for veterans, Social Security, supplemental security income, other retirement programs, and income coming from other programs administered by any federal, state, local, or nonprofit entity. So it's really broadening the definition of income outside of just employment-based income. We do see a lot of housing providers that have a preference for employment income or really focus on employment income. And they need to be aware that there's other legal sources of where people can get their household income from. So it may also include other types of housing vouchers, child support, alimony, and others. So I don't want to use any lingo that people are not familiar with. There's a lot of alphabet soup in housing. So one that we talk a lot about are these housing choice vouchers. They're often abbreviated to HCVs. They used to be known as Section 8 vouchers. And these are rental assistance that's funded by HUD. They're administered by different entities, including local public housing authorities or PHAs, to help households with low income pay their rent. They pay with a voucher, they pay a fixed portion of the rent, and the program pays the remainder of the rent directly to the landlord. The HUD-VASH program is a specific type of voucher that aids veterans who are experiencing homelessness and their families. That program also includes case management and clinical services coming through the Department of Veterans Affairs. So to explain kind of the term source of income, income generally deals with how much. The source of it deals with where it's coming from. So landlords and housing providers may always consider a tenant's ability to pay their rent and other financial obligations that come with the housing, such as their utilities. The source of income protections are intended to help cost-burdened families or individuals, which is that they pay 30% or more of their monthly income on rent and utilities. And then also helping severely cost-burdened people, which are households that spend over 50% on rent and utilities to obtain and maintain housing. I was just listening to a news story this morning about households that spend over 80% of their income in a city in the United States because the costs are so high. So these programs and these protections are really geared towards helping people not having to spend the majority of their household income on rent and utilities, which doesn't leave much for anything else like food, medication, clothing, other daily needs. The new laws do not include the following: income that is not from legal sources. So it should be legal sources, and it also should be ongoing sources of income. So it's not going to protect income that is not coming from legal sources and not on an ongoing basis. It also has a caveat that housing assistance agencies have to move within a 30-day period after the landlord provides all the information. So just trying to help speed up the process to make sure that things go smoothly and can move fairly quickly to get people housed to use these resources to access the housing that they're intended to access. So the laws kind of go through a series of prohibited behaviors. So we're going to take a look at that, but most importantly, look at some examples of what potential violations could be. So a landlord who's renting out should not, on the basis of source of income, deny or terminate someone because of where their income comes from. They shouldn't make any distinctions, discriminate, or restrict any tenants, current or prospective, in the price, terms, conditions, fees, or privileges related to renting that unit, or also in giving them any of the access needed for the facilities and services that come with renting a unit on that property. So it really covers the whole relationship. So it'd be illegal to refuse to rent to someone because they have Social Security income or disability income. Charging extra fees, a higher deposit or higher rent because they have a voucher would be a violation. Not maintaining the units where voucher holders live to the same standard as the other units would be a violation. Not providing equal access to facilities and amenities based on the tenant source of income would be violations. So again, back to the law, it's a violation to otherwise make unavailable or deny a rental unit to someone if they're otherwise eligible, but for their source of income. So if they're otherwise qualified, but it's where their money is coming from that is the issue, and that's the basis of the denial, that would be a problem. It's a violation to represent to a prospective tenant that a rental unit is not available, even to see it for inspection, let alone rent it or lease it when it is available. And that's a very consistent fair housing standard. It's a problem to withhold an available unit or an available home for sale knowingly on the basis of a protected class. So that's something that is very familiar if you've had fair housing training before, and it's just included now in these new protections. So making it unavailable if the tenant is otherwise eligible to rent the unit because of their source of income, or telling an applicant with a VASH voucher that the unit has been rented even though it has not been rented would be a violation, and not allowing someone to see the unit or have it inspected because they have alimony income, for example. Other specific prohibited behaviors, it'd be a violation to make any distinction, discriminate, or restrict anybody in the price, terms, conditions, fees, or privileges related to the rental on the basis of the fact that they use or they have emergency rental assistance. And also it would be a violation if they have when you set a certain threshold level of income to exclude any source of income in the form of a rent voucher or subsidy when calculating whether your income criteria have been met. That particular subdivision does not include emergency rental assistance dollars. So requiring additional references would be a change in your normal practices, which would be a violation, imposing additional or unreasonable screening criteria, ignoring voucher payments when determining if they have enough income when calculating total household income. And then having any advertisements or statements, saying this is for working people only or no Section 8 allowed would be violations, or requiring residents to have a job to rent somewhere or work a certain number of hours could violate the source of income protections as well. So any attempts to discourage the rental or lease because of source of income would be a violation. And again, both of these standards are very familiar under other fair housing laws. Discouraging any party because of a protected class from pursuing housing is a violation. And then also any communication or advertising. If anyone playing any part in any messaging going out to have a preference or limit could be a violation if it's discouraging people on the basis of their source of income. And then the last two standards are kind of upholding the rights of people to report housing discrimination that violates this law and also protects employees. So you cannot be coerced or incited or induced as part of your job to violate this law. So that's more like a whistleblower protection. And then anyone who does want to exercise their rights under this law should not be coerced, intimidated, threatened, or interfered with. And so is it okay if I finish, Bree, and then you can pop in? Okay. So as I mentioned, the second set of laws that was amended so that they kind of are in alignment now is the Michigan Tenant Landlord Act, which gives us a little bit more detail on who is covered. So this section does not apply. So these source of income protections in rental housing do not apply to a person if including all related entities that that person has if they are a landlord of fewer than 5 rental units in Michigan. And so that is broadly defined. Person could mean an individual, a partnership, an LLC, which is a limited liability company, an association, any sort of rental attached to that person. If they indirectly or directly control it with or without another person, they would be covered if they have more than 5 rental units in the state. So do we want to take a question now?
Yeah, we have a few questions that popped up. The first one is if the property has a HUD-approved working preference for the Section 8 waiting list, are those now a violation under source of income?
That's a great question. I think we'd have to take that to the State Department of Civil Rights to get some clarity, and we'd be happy to do that. Yeah. I generally think that the federal requirements could trump this, but it doesn't hurt to make sure.
Yeah. Another one, why are landlords able to ask for proof of income that's 1.5 times the rent? I have not
Why?
heard that standard before, 1.5 times. Um, if that person wants to provide some more clarity, maybe that may be helpful.
Yeah, generally, they can set any standard that they want. We often see proof of income for up to 3 times the monthly rent. And we don't have rent um, caps here in the state of Michigan. So there are very few communities that do have kind of calculations that go too high in calculating rent, but we don't have limits here in Michigan.
And then the last
So,
one
oh yeah.
is 3 times rent in income is very common qualification I've seen. I've wondered if there are any problems regarding fair housing this can bring, or can you shed any light on this? Thank you.
Yeah. So very similarly, as far as from the fair housing perspective, any standard or 3 times, 2 times, 1.5 times the rent, any standard that is set should be uniformly applied, consistently applied across all protected classes. So that's really the only angle that fair housing would have on this. We don't have rent caps. So as I mentioned, landlords can set the standard for how much income they'd like to see. But from a fair housing perspective, we just wouldn't want to see those standards change based on any protected class.
And with this protection, I think thinking about it as all income that is being received is income, so that needs to be counted towards that 3 times the rent calculation. So that is included in that calculation because it is, whatever, if it is a voucher, the voucher is counted as income. So I think that's the challenging part with the 3 times the rent is because it's two different sources, but you have to combine them to think about it in that sense.
Yeah. Okay. So oh, this was essentially what I was saying. So any landlord with 5 or more housing units in Michigan is going to be covered. So again, this is broadly defined as a person who owns the housing or a person who leases or subleases it, any person who's authorized to exercise any aspect of managing the unit, including the person that acts as the rental agent or actually receives the rental income. So it's broadly defined. It covers property managers, rental agents, real estate agents, brokers. The other thing that I want to say is that there is a lot of gray area under this new protection. So we have lots of questions and we are working with the state to get as much clarity as we can. They have said that a lot of this will have to be determined by case law. So we're just sharing best practices to the best of our ability to help manage risk on the front end. But there are a lot of unanswered questions for these new protections for sure. So we're working with the state as best we can to get clarity. But some of the questions will have to be decided by case law. So again, we'll keep you posted on that as we learn more. But in the meantime, we recommend these best practices, providing equal treatment to all applicants and tenants, regardless of source of income, accepting and counting all income that comes from lawful ongoing sources, not expressing any limits or preferences about income sources or employment status in ads or any communication unless you have that designated program under HUD dollars, for example, work with an agency that administers any vouchers or assistance and be responsive in a timely manner as is expected of them. You may want to update your policies and practices if you are a covered entity, if necessary, to enter into third-party agreements or accept third-party payments, and do not retaliate against tenants or applicants seeking to utilize or enforce their fair housing rights. So we're going to do a quick poll here, a little question about testing our knowledge here. So I'm going to review everything for those of you who cannot read it or access it. So we have a question about which of these 3 scenarios would be a fair housing violation under these new source of income protections, and you should be able to choose all that apply. So our first option is someone with a voucher applying to a property but being denied because they have a history of recent outstanding rent and unpaid damages. Our second scenario is a voucher holder being charged higher rent because their voucher covers more. And our third one is someone with a voucher puts in a maintenance request and doesn't hear anything for a month. Their neighbor who doesn't have a voucher had a similar issue and had it addressed within a week. So which of those 3 are potential violations of these new protections? And it should be multiple choice. So I'll give you another 30 seconds or so. And just a reminder, please use the Q&A feature so that we can make sure to get to questions that you may have. I am going to go ahead and close this poll and share the results here. So the second and third scenarios I see as potential violations of these law, and 82% of you even equally said yes, you agree that those would be violations. I think someone with a voucher being denied because they have recent outstanding rent and unpaid damages, if that's a standard that the landlord would apply to any other applicant, I think that would be a standard that would not violate these new protections. So thank you for playing along. And we will move on to some advertising. This is something that we've already briefly talked about, but as I mentioned, a lot of those standards now under source of income have been standards under fair housing laws for quite some time, going back to 1968, as a matter of fact, when we had our first four protected classes of race, color, religion, and national origin. It was very clear that it was unlawful to have any sort of notice, statement, or advertisement that had any reference to a protected class or create an advertisement or messaging that was an intention to make a preference, have a limit, or discriminate. So very, very broad. And at our Fair Housing Center, we offer to assist with reviewing ads and providing any, risks that we would see in the language because we understand this is a very um, legalese type standard. But essentially, advertising provisions are very broad. And so we want to make sure we're not putting out any communication, whether it's online, in print, verbal, flyers on your website, that has any sort of preference or limit. And now, how we advertise is very different these days. There's all sorts of ways to do it. So you have to make sure to analyze your advertising, not only the content of it, but also just how it gets out into the community because advertising and targeting of advertising can leave people out. It can not get everyone information about available housing opportunities, which is a problem. And of course, you want to cast, as a good business practice, a very wide net for the best reach into the community. We also see advertising targeting vulnerable consumers for predatory products, services, or pricing. We've seen examples of that in the past. We've seen messages that discourage or just flat out ban certain housing seekers. And if it violates fair housing law, that's an advertisement that will be found to be violating the law as well. Advertising different prices or conditions to consumers, steering people to particular neighborhoods based on a protected class. And sometimes we've even seen charges of higher amounts to show ads to some consumers. So some of the online platforms, for example, have been successfully challenged by HUD and in the courts for their mechanisms being found to be discriminatory in how they get information out. For example, a rental ad targeted to predominantly Black neighborhoods that has prominent notices of no criminal records and good credit only would be a problem if the comparable ads sent to white neighborhoods do not have that language. Or targeting a mortgage ad for men that includes detailed information on current mortgage rates, but the ad targeted towards women simply says getting a mortgage is easy. That is not equal treatment and sharing the same information regardless of protected class. So not a best practice. So overall, you want to focus on describing the property. If you have programs attached to the housing, you want to focus on the program, not the people. We often see the inclination is to say this property or this house is ideal for this group of people or this specific person. And because of the list of protected classes, it's very hard to do that without violating fair housing. So describe the property, not the people. Make sure that you're reviewing all of your promotional materials, any newspaper or internet ads, any verbal statements being made. When in doubt, take it out. Don't press print, don't press publish or post, don't share until you've reviewed it with your fair housing hat on or reached out to your local fair housing center with questions. We do encourage you to use the Equal Housing Opportunity logo, and HUD does have posters available as well. So you want to display those in places where rental transactions take place. You also want to make sure all of your staff, residents, and applicants are equally aware of all of your applicable criteria and policies, especially if you're running any rebates or specials. You want to be consistent as much as possible across the board. Okay, we're going to do a quick poll question on advertising. There's two questions here. So we are asking true or false. A newspaper or online ad that describes the type of person a landlord wants to rent to is acceptable under fair housing laws. And number two, there's no fair housing risk when using human models in advertising. Okay, trying to keep up with questions, but also I want to make sure we're moving forward. I'm going to go ahead and end the poll and we'll take a quick look at our answers here. But I can tell this is a very experienced group because 92% of you said our first one is false. I agree. We want to talk about the property, not the type of person. And our second one is there is inherently risk as soon as you start using human models, unless you have a space and a way to include a lot of diversity across all of the protected classes. So as soon as you do use a human model, there is some fair housing risk. The lowest risk strategy would be not using any depictions of human models. And 89% of you said that was false. So great job there. Those are both false. Okay. And we're going to talk about screening very quickly here. There's just some, detail for each of these bullet points, but overall, this is the takeaway for best practices for screening. You want to make sure you have screening standards, that they are relevant and that they are fair, that you are only using accurate and recent records. You want to follow your policy. Consistency is so key. It's helpful to be transparent with applicants and allow them the opportunity to challenge information that comes up, especially negative information that impacts their access to housing. So establishing relevant and fair screening criteria. So you want to development, document, and use clearly defined requirements, as we've talked about with, minimum household income standards from all legal ongoing sources. You want to focus on information that's evaluating their likelihood of complying with the obligations of being a tenant and what's in the lease. Prioritize the use of recent records, review your criteria, especially with these changes in law. You want to make sure everything is up to date. We're in the process of updating a lot of materials of our own, so we understand that's a lot of work, but it's really important to make sure you are keeping up with fair housing laws and use that list of protected classes. It can help you decide if anybody would be potentially treated differently. You want to use recent and accurate records. A lot of the tenant screening data that's available can be incomplete, outdated, and incorrect. Oftentimes there are issues with people who have the same or similar names being attached to the records are attached to the wrong person. So it's important that you record match multiple pieces of information to make sure you're evaluating accurate information for the particular applicant you have. And you don't want to use any records that have a positive income. For example, if there was an eviction where the tenant prevailed, that should be discounted. So overall, where's the data coming from? Is there any data cleanup coming as part of the process of this data source? How do they do it? How often do they do it? We have found, especially court records and public records can be very incomplete and outdated. Follow your policy and make sure you're not collecting any information that falls outside of your policies, whether you're looking at criminal background, credit, or their housing history. So make sure you are focusing only on records that are tied to your stated policy. For example, don't consider a misdemeanor if your policy is screening for felony convictions. You want to be transparent, so having policies that are written and publicly available, whether you provide copies or have them up on your website, is beneficial. It helps people know how they'll be screened. It helps them decide whether they want to apply, if there's a fee, if they want to pay that fee. They should also be provided with information on how to submit mitigating circumstances, or if they're a person with a disability, a reasonable accommodation request, and how they can contest, records that are not accurate or complete or relevant. If they are denied, they should have the opportunity to challenge any negative information that disqualifies them. You can give them the information that was used in the review and let them know the specific standards that were a barrier in a way that is easy for them to understand why they were denied. And then they would have the chance to show, even if the record is accurate, that they can comply with tenancy obligations. Maybe they attended a financial literacy or rent ready program, rehabilitation program, or maybe they've had a change in their education or employment status. Some additional factors, credit history and credit score screening is a very common standard that is used in renting housing. It was developed as a means to assess credit worthiness or the likelihood of paying back borrowed money on time. And credit scores do not capture timely rent, utility, or other bill payments, nor do they have any information about payday or non-traditional lender payments. So they are a tool, but they don't capture the whole picture. And that's where we encourage the allowance for explanations and the request for accommodations due to a disability. And some takeaway questions, what are we trying to get at? We want to know if they'll pay their rent. Is there another way that we can get at that? And that would be one tool, income verification. So there's no known studies on the relationship between credits, rapports, and scores and successful tenancy. So having no credit history or limited credit history is even less relevant than having a bad credit history. Admitting applicants so long as they don't have a negative credit history might be more precise than requiring a positive credit history because some people just don't have credit in the traditional ways that would have them show up. Um, Automated screening tools can be programmed to rely on other available financial information as a substitute for not having a credit score. So those are alternatives that could be explored. The most commonly marketed screening component is looking at eviction history. These are pulled from private databases, from court records. And according to the Urban Institute, there's no national requirements for courts to clean, maintain, or share data in a specific way. As a result, there's tremendous variability and at times inaccuracy in court records. So do not rely as a best practice on eviction records that are old, incomplete, irrelevant, or where you have a better measure of an applicant's behavior available to you. You want to distinguish between the different types of evictions and the varied outcomes. As I said, where evictions where the tenant prevailed, where a settlement was reached, or it was dropped should not be considered. It shouldn't count against them. Neither should no-fault evictions where the property was removed from the market. The tenant had nothing to do with that decision. Applicants should get the chance afterwards to have their record disregarded and corrections made. So again, what do we need to know about the eviction to find out if they can be a good tenant now? Why did it happen? When did it happen? What were those circumstances? What if it was long ago or if those circumstances no longer apply? And note under the Fair Credit Reporting Act, tenant screening companies should be including existing disposition information for eviction records. Using criminal history to inconsistently screen, deny lease renewals, evict, or otherwise exclude individuals of different protected classes from housing may be illegal under the Fair Housing Act. So a note here again, we'll talk more about this in our second half, but reasonable accommodations, which are changes to rules, policies, services, and procedures because of a disability would apply here. So it might mean making an exception to admission policy or disregarding certain criminal records. A person's disability might make it unlikely that they would reoffend, or they've got past criminal history related to a mental health disability that has since been treated. Some best practices according to or focusing on procedures, you always want to check for state or local laws that may limit ability to run criminal background checks. There are several cities that have fair chance acts. Michigan has had several proposed versions of statewide protections that have not passed, but there's a lot of advocacy around that. So it's important to check those laws and make sure within the cities where you're operating that they are not on the books, or if they are, make sure you're familiar and in compliance. You may have program requirements according to funding or how your housing has been set up. So look for regulations or restrictions tied to the funding for the program that you're running. You want to have written screening standards that is available to all applicants. Of course, you want to be consistent and treat comparable criminal histories similarly. Again, back to that consistency of treatment. And of course, document. That's always a best practice that we recommend. Document the screening completed, what was considered, and the decisions that were made. For those of you who are working in properties that are LIHTC properties or low-income housing tax credit properties, you want to see the LIHTC compliance manual specifically. That is linked at the end of the presentation, but it does require that owners establish written screening criteria to permit the admission of certain individuals based on drug-related criminal behavior or those who are subject to the state lifetime sex offender registration program, or those who abuse or have a pattern of abuse of alcohol that interferes with the health, safety, or right to peaceful enjoyment of the premises by other residents. Owners may choose to expand those requirements but they must include the written standards I reviewed there. It's not a requirement to expand those standards. An example of a retaliation case that HUD charged out of New Hampshire, both all three parties, management and the landlord, were charged with violating the Fair Housing Act by retaliation, threats, and interfering with the tenant's fair housing rights. The tenant is a Hispanic male. He'd lived there with his minor child since 2019. He filed a HUD complaint in June of 2023, and they submitted their answer to HUD in July. In November, the tenant was notified that his tenancy was being terminated for false statements made on his rental application. Again, this was back in 2019, that were recently discovered when a background check was completed. The complaint alleged that, or the respondents alleged that he failed to disclose a conviction for reckless road endangerment from 2005 when he was 19, and they filed an eviction action in court. The tenant told his HUD investigator that, in his opinion, he was being retaliated against by having this background check being conducted 4 years after he moved in. So his HUD complaint was amended to include that claim of retaliation. And the respondents admitted that they don't do complete background checks on residents, but they did one on him because of his fair housing complaint. So they admitted that they retaliated. And the state court held that the eviction following his report to HUD was a violation of New Hampshire law. And then it also found that there was credible testimony that the tenant had in fact disclosed his criminal record to the rental agent when he submitted his application, and that they told him not to worry about it. So a little lesson there about retaliation as prohibited. We have a quick poll here again on screening. Now, it does say true or false, but really it's more of is this a fair housing issue? So true is going to be yes, false is going to be no. Sorry about that lingo. A landlord enforces a no felonies policy to reject a male applicant, but waives it to approve a female applicant. Is that a fair housing issue? What do you think? Now I'll give you another 15, 20 seconds here. This is a short and sweet. Okay, I'm gonna end and share. A little more disagreement here. We had 86% of you say, yes, this is a fair housing violation. That is true. And it is a gender variance, right? So the policy is there's no felonies, and they waived that to approve a female applicant so that male applicant could complain under gender protections. Great job. Moving forward here. Got a slightly more complex question. What would you do? So we have a scenario here. It is your company policy to do a criminal background check on all applicants. A Hispanic family is informed of that policy when they inquire about renting. Staff discovers, however, that there are no criminal background checks in the files of the last 3 approved white applicants. So what would you do? You can check any of these 4 options, or as many as you like. 1, run a criminal background check on the family. 2, use the same criteria that was used to assess the last 3 approved applicants. 3, look into why the policy was not being followed. And 4, train all staff and reinstitute the policy consistently going forward. Got a lot of fast responses from our experienced group here. I'd love to see that. And again, we'll give about 30 more seconds here to give you time to discuss and vote. Okay, about 15 more. All right. I'm gonna end it and share. And again, these are all anonymous just to kind of help us apply our thinking on fair housing. So we had most of you say train all staff and reinstitute your policy at 88%, and 86% look into why that policy is not being followed. And I very much agree with those last two. And 47% of you said use the same criteria that was used to assess the last three approved applicants. And I would concur with that. That would help you be consistent now that you've discovered the error. I would not run a background check on the family so that you are consistent with what you have been doing most recently. But look into it, make sure that the policy is being applied going forward, and make sure all staff understand what they need to be doing. So great job there. At this point, I am going to turn it over to Bree to talk about applications and selection. We'll have a couple of short sections here, and then we'll take a short break.
Great. Thank you so much, Liz.
Mhm. Oh,
Okay, and we're going to start off with a poll, back-to-back polls, really testing you guys today. This is a 301, so we do want you to be, sorry, this was,
if you need me to launch, I'm happy to
there it
launch.
is. I found
Okay.
it. We want you to be on your toes and be really thinking about things critically. So for this next poll, is this a fair housing issue? An older adult is contacted by a housing provider because their name came up on the waiting list. The manager wants to see the applicant in person before they move forward with the process. Is this a fair housing issue? Yes or no? The second one, a Black man applies for senior housing near his doctor and across from the hospital where he is receiving treatment for an ongoing illness. He calls regularly and is always told that he is on the waiting list and will be contacted soon. Is this a fair housing issue? Yes or no? I'll give folks about 30 seconds here. You guys are going pretty quickly on this one. About 20 more seconds here. Okay, get your answers in. Again, like Liz mentioned, this is not graded, not required um, for anything. It's just really for your engagement and to test your knowledge. Okay, I'm going to go ahead and share the results. So for the first one, with the housing provider wanting to see the applicant in person, with the person being on the waiting list, this is a fair housing issue. This would raise a lot of concerns. Not only we often see this for independent living. I know individuals want or housing providers want to see if the older adult can be independent, but that is a violation of fair housing. It could also be utilized in any of the protected classes. So at any point, if a housing provider wants to see a person, they could be using a protected class to say whether or not a person could live there. So that's just that it can be a fair housing issue. For the second one, with the Black man applying and, just calling regularly and seeing he's on the waiting list, with the information that you are given, this is correct. It is not a fair housing issue. However, this example does come from a case where a Black senior was on a waiting list. He was working with a working with the leasing agent, talking to them. They knew everything about the leasing agent, but it was found. He came home one day and his white neighbor was packing and he asked where she was moving. And she said, "Oh, I'm moving to ABC Apartments." And he was like, "Great, that's awesome. I'm on the waiting list there. Like, how long were you on the waiting list?" She was like, "Oh, I waited 2 months." And at that point, he had been on the waiting list for 7 years. So they were maintaining two wait lists based on race. So on the face, some things may not be a fair housing issue. So that, just kind of it wasn't a trick question because the information you were provided, it is not a fair housing issue, but we just wanted to provide that context to you. Next slide, please. So when doing your process for applications, really do make sure it's uniformly and you're doing everything, following your policies, but accept all applications as you get them. Have a wait list if it's feasible. Make sure you're date and stamping everything using the first come, first serve model. I'll do your credit checks, income references, all of those things. Identify any legitimate business reasons for any of your basis of decisions. Make sure you make note of that, document everything. Make sure you're thinking of your protected classes as you're thinking about the application and making sure, and that really could be with the policy overall and the process overall. Think about your protected classes and if this would impact anyone, your process, any of the protected classes. Make sure it's being applied consistently with all staff. Make sure it's accessible. That a person may ask for a reasonable accommodation or a reasonable modification to your process or your policies. So just be keeping that in mind. Next slide, please. When establishing fair criteria, develop, document, and use clearly defined requirements. Make sure that it's, clearly defined and provided to people that are applying. Cross-reference again with your protected classes. Is anyone being treated differently? Are they being applied differently to different people? And just continuously, regularly review all of your criteria and document that you've reviewed it and be consistent across the board and that everyone is aware of the applicable criteria to apply. Ensure that application supports the criteria and fair housing. Again, these are all going to sound similarly the same, but we're just really trying to hone in that all of your criteria, your application is thinking about the protected classes, and you're questioning it and reviewing it with that in mind. What business justification do you have for collecting information on the application? Could it be used against someone based on a protected class? And can you show that it did not influence that decision? So that's some of the things that may come up if you were challenged on if somebody brought up a fair housing allegation. So just be thinking about that. Be consistent in your verifications. Make sure it's consistent across the board. If your policy is to call past landlords, make sure you're calling all past landlords for every applicant. Get permission before running credit checks and background checks. Next slide, please. And really just be thinking about what information is necessary at what point. You should be collecting information that is determining if a person qualifies for the available housing. Would they be a good tenant? Ensure that unlawful questions are not asked in person or on the application. Review the information that is collected but not used. If you are realizing, oh, we collect this information, but it's not used in any way to inform if they can live here, then there may not be a reason to have it on the application because it could open you up to risk, especially if it's in regard to a protected class. There is a prohibition on blanket inquiries, but for a landlord to ask about an applicant's disability. It can't be an overbroad question to, asking about the nature or of the disability or the severity of the disability. You can't ask the applicant or tenant to, waive their confidentiality regarding their medical history. So that is a very clear prohibition on asking that type of information. Some common things that we see fair housing issues and can open you up to risk, having an outdated list of applicable fair housing protections listed on any of your policies, on any of your documentation. It could be even having outdated information on your website. So that is also something that you should be looking at. Practicing your practice is different than the plan, so you're not actually following a policy that it's kind of differing. So making sure that you're practicing what is in use. Incorrect or more narrow definitions that don't align with the legal definitions of protected class. So if you're looking at a protected class, but there's a more broader definition, then that should be your definition of that protected class. Unreasonable or outdated or blanket occupancy standards that do not take into account the size of the layout, the bedroom sizes, and things like that. And we'll cover that after the break. And ensuring that your process and your criteria are clear, they're easily readable, and they have a ease of use. Some best practices for tenant selection is, include all the criteria in the decision-making process, be specific. Again, everything should be written out and should be accessible. There should be an appeals process, and that should be communicated to people that are applying. Make sure you're stating the right of an applicant with a disability to request a reasonable accommodation. Make sure that is apparent in your messaging. It's important to include a non-discrimination statement as well in your documents in your application and things like that. Again, refer to your list of protected classes that covers the property area. So make sure you're keeping in mind the local protections and doing that research. Thinking about how would the applicant or a resident treatment vary? Is there any unintentional barriers? Who's being left out? Can you defend any findings as non-discriminatory? Ensure that there's housing choice. Make sure you're not making choices for the potential resident. We often see this for people with disabilities and families with children. So make sure they're getting all of the information that they've asked for. So if they've asked for, I want a 2-bedroom unit, and you have one on the first floor and the third floor, make sure they're getting both units. As an option. The same with people with disabilities. Those people can make decisions for themselves, and that should not be the housing provider's choice. It's the individual's choice. So just make sure that the choice is available. Next slide, please. So overall, what is this takeaway? Just again, be thinking about what you need to know to make sure that the person is going to be a good tenant. Think about, why are you requiring or asking this question? What are you trying to get at? What is this question trying to get at? Is it actually being used? Just make note again, if you're requesting or have information that's related to a protected class, make sure you have a business justification tied to it, because it opens up risk when you have that information, because you have to show that you did not use that information to determine if somebody can live in your property or at your property. Is it actually something as required, or is it kind of just something that's been passed down for generations of leasing agents and owners to say that this was a requirement, but maybe it isn't anymore. So make sure you're verifying that, and what sources you have to say that it is required. Next slide. Okay, now we will do a 5-minute break. So go get some coffee, water, stretch, bathroom break, and folks can return at, we'll do 10:09. We'll give you a 6-minute break. Okay, I'm summoning everyone back. If you are can hear me but not at your desk, we're gonna get started again for our next section. We will be moving into occupancy. Next slide, please. When it comes to reasonable occupancy standards, the Fair Housing Act specifically allows housing providers to adhere to any reasonable local, state, or federal restrictions regarding to the maximum number of occupants. This could include a property maintenance code, zoning code, a minimum floor area requirements, or other provisions that are noted in any of, local, state, or federal restrictions. The occupancy restrictions often consider the number and size of the habitable rooms and the overall size and configuration of the unit. So we will do some the activity today to kind of calculate that and look at that. This chart comes from the International Property Maintenance Code. It's a best practice if your community does not have any restrictions to just defer to the International Property Maintenance Code. So the IPMC is what it's called as a shorthand. And for 2021, these are the limitations. So from 1 to 2 occupants, the living room has to have 120 square feet. There's no requirement for the dining room. And then for the bedroom, it's 50 square foot for the first occupant, or for each additional occupant, but a minimum of 70 for a bedroom for one occupant. And then going from 3 to 5, it's 120 again for the living room, 80 square feet for the dining room, and then again, keep adding that 50 square feet per occupant, and 6+ occupants, 150 square feet for the living room and 100 square feet for the dining room. So we will now do some calculations and look at some examples on how to calculate this. So we have a floor plan right here. Our first bedroom is a 12 by 10. Our second bedroom is 13 by 12. We have a dining room of 9 by 10 and a living room by 12 by 16. So to calculate this, we would take the size. And so for the first bedroom, a 12 by 10, it's 120 square feet, which is 2 allowable occupants within that first bedroom. The second bedroom is 13 by 12, which is 156 square feet. That would allow for 3 occupants in that room and bedroom too. The dining room is 9 by 10, which is 90 square feet. So with that standard, the square footage would be 3 to 5. And then the living room is large and it's 192 square feet, which is equal to 6 allowable occupants. So with that being said, I'm going to launch a poll and I want you to determine how many people can occupy with this floor plan. Sorry, I gotta get the polls back up. Okay, so what this 2 bedroom unit can hold how many people? 2 people, 3 people, 4 people, 5 people, 6 people, or 7 people? Liz, if you want to go back to the next slide so people can have the calculations up, that may be helpful. So how many people can live in this 2 bedroom unit? What is the maximum occupancy? I'll give folks 30 to 45 seconds. Okay, get your answers in and then we will reveal the answer. All right, I'm going to end the poll there and share the response. See, so this was really mixed. So the two-bedroom unit based on the IPMC would be 5 occupants. So the living room is large enough to accommodate 6 or more. However, the sufficient sleeping area, the 2 bedrooms, is for 5 occupants, two in the first bedroom and 3 in the second bedroom. Also, the dining space is for up to 5 occupants. So 5 occupants in that unit could be the maximum. So 32% of you, I agree. Another one here. With this floor plan, we have a bedroom that is 11 feet and 7 inches, and then 13 feet and 10 inches. And it has a combined room and dining room for 19 feet, 7 inches, and then 13 feet. So we're again going to calculate this one. We're going to, for the only bedroom, is 160 square feet, which is 3 allowable occupants. And then the combined living room and dining room is 254 square feet and has allows for 6 or more occupants. So now we are going to determine, based on that, how many people can live in this 1 bedroom unit. Two, three, four, five, 6 or 7 people can live in this 1 bedroom unit for maximum occupancy. Little quicker to the answering today, so for this one, so I will give folks about like 20 more seconds. I want to be able to make sure we can cover all the content. Alrighty, get your answers in, and I will go ahead and share the answer. Okay. So for this one, I would agree with 66% of you that 3 people can occupy this 1 bedroom unit. Okay, next slide, please. The living room again can accommodate up to 6 people. However, there's only sufficient sleeping area for 3 occupants. So this 1 bedroom unit can hold 3 people. Great. So now we have another poll, really testing you all this morning. So these are true and false questions again on occupancy. So true or false, a landlord can have a policy that residents cannot have more than 2 children in the household. True or false? So can this be a policy? Have more than 2 children? The second one, a property owner has the right to request additional information about daycare arrangements, custody, biological parentage, what room each child will sleep in, etc., when families with children apply. True or false? You do have a right to that answer, or right to that information. Then the last one, it is a good idea to be familiar with local occupancy standards that apply to each of your properties and ensure that your policies are not more restrictive. True or false? I'll give about 45 seconds. Okie dokie, get those final answers in and we will go over them. Alrighty. So for the first one, a landlord can have a policy that residents cannot have more than 2 children in the hospital. That is false. There should be no limitations to the number of children in the household, as this would be could be an allegation for fair housing for families against families with children. And the second one, property owner has the right to request additional information about the daycare, custody, what room each child will sleep in, etc. True or false? That is false. Again, taking in more information that is needed really has a increases your fair housing risk. It's a good idea to be familiar with local occupancy standards that are to apply to each of your properties. I would agree with the 99% of you. That is true. Be familiar with your local occupancy standards. That is the overall takeaway from this section is make sure that it is you're using the right restrictions for where your property is. Okay. And our final poll for occupancy. So yes, this section is mostly poll related, but that is, we think, the best way to, um, sorry, these are out of order. There it is, to test your knowledge. So where do you find information about your local occupancy standards? Your management office, code of ordinances on local government website, example, the city, online municipal code libraries, local code enforcement officials, and local fair housing center. So this should be multiple choice, so please choose all that apply. The second one, you hear a maintenance person working outside tell a visiting family of six who inquires about open apartments that there is no housing available for a family of that size. What would you do? Review your current occupancy standards to verify that if that is accurate or not. Communicate the right information to the family. Inform the maintenance person that all inquiries about availability should be sent to the office. Or, sorry, there's two more. Tell the family they have too many kids and you're not set up for them. And then provide a refresher training to all staff. So these are a little bit more to the question. So I'll give some more time on these. Give about 20 more seconds. All right, get those answers in. Again, if you miss it, it's all right. Doo, doo, doo. Okay, share those answers. So for the first one, where do you find all the information? All of those places. Those are all acceptable information. Look to your management office, look to the municipal code libraries. Really, all of these are the resources you can utilize to find that information. So we want you to know that. And then for the second one, you hear the maintenance person outside tell a visiting family that there's no housing available for them. So what should you do? It would be important to review your current occupancy standards to make sure that's accurate or not. Communicate the right information to the family. I would agree with 73% of you. Make sure you inform the maintenance person that, of your policy, if that's your policy, to for all people to be sent to the office, which I think would be a good policy to have. And then provide a refresher training to all staff would also be the other thing you could do. Great. All right, now we're going to move on to effective communication. Next slide, please. This is a case out of California. It happened in September of 2024, where 30 senior housing facilities settled a complaint which alleged that facilities discriminated on the basis of disability by failing to provide ASL interpretation for seniors with disabilities. So testers contacted the properties to request ASL information on the behalf of fictional relatives. And then under the settlement agreement, the Oakmont paid the Fair Housing Federation $110,000. It will also modify existing policies and create policies for people with hearing impairments and deaf applicants. And again, staff would also receive training on the laws. So it's really important to just know what type of services you can provide to people with hearing loss, being hearing impaired, people that are deaf, things like that. So that's really important to know for your property. Next slide, please. Another poll. This is on effective communication. So, what is the best way to communicate with someone who is deaf? Move a little bit quicker on this one, so we'll give about 30 seconds on this. A whiteboard, pen and paper, texting or email, have them bring a hearing friend or family member, how the person requests to communicate, and shout loudly. Best way to communicate with someone who is deaf. All right, I'm going to end that poll. Again, I just want to move through this. So I would agree with 94% of you. How the person requests to communicate is the best way, the number one best way to communicate with someone who is deaf. However, you can utilize a whiteboard, pen and paper, texting, or email. If they bring a friend with them or family, you cannot request them to do that. But how the person requests to communicate is the absolute best way. Next slide, please. So best practices, think about your reasonable accommodation policies and recognize and act if somebody, um, you know, asks you about having an ASL interpreter. Know your policies. Follow the lead of the person requesting it. A request for an ASL interpretation for an in-person service should be evaluated as a reasonable accommodation when requested. Especially for a tour, completing the application, or signing of a lease. Know how to call and arrange for an interpreter when requested. If the first option or request doesn't work, make sure you offer alternatives. So if there's a delay, if there's timing concerns, make sure you're communicating with that person if there are anything out of your control, and make sure you're offering alternatives. Video relay interpreting is an option. It can work in an unexpected or quick meeting. However, just understand that that does not work for everyone within the deaf and hard of hearing community. Most people within the community prefer a live interpreter over VRI. So it happens way too often where individuals with hearing impairments are forced to use VRI as the primary mode. Again, let the person tell you what works best for them. People who are deaf and hard of hearing can also use 711. That is a service only for people who are deaf and hard of hearing. Some more best practices: keep line of sight free for information and visuals. Look directly at the person you're communicating with, not the interpreter. Use I, you, avoid third-party phrases as ask her or tell him. No need to speak louder or shout. Speak at a reasonable pace. Allow time to receive the information and respond. And then there's some resources there as well. Before we move into RAs, RMs, we do have a poll here. Which is false? Which of the following statements is false? Tenants can request an accommodation or modification at any time. Tenants with observable disabilities or disability-based needs can be asked for supporting documentations. Tenants can only request one accommodation or modification. Tenants' request must not be unreasonable. What is false? Give about 15 more seconds. All right, I'm going to end that poll, get in your answers. And I'm going to share those results. I agree with 67% of you. The statement that is false out of this list is tenants can only request one accommodation or modification. Tenants can request as many accommodations or modifications that they need for their disability-related needs. There should be no limit on those. Next slide, please. All right, now I'm going to turn it over to Liz, who will discuss reasonable modifications and accommodations.
Thank you, Bree. I know there are some questions in the Q&A. Since they are about disability-based protections, I will circle back to them as we kind of cover this section. I am going to move a little bit more quickly, keeping an eye on the clock because we have more poll questions for you and we want to make sure to give you time to answer those. So modifications, as we've talked about in the past, are the physical and structural changes made to any part of the premises that are either occupied or about to be occupied by a person with a disability so that they can have full enjoyment of their housing. Examples, we've got grab bars in the bathtub or a ramp up to a door, but it also can be ramps to different buildings on the property or the individual's door, swapping out doorknobs for bar or lever style handles, which are easier to use than round doorknobs, different stoves with controls on the front panel, and flashing lights maybe for a phone or doorbell notification. So you can sort of see on my example slide here that they put up a accessible entrance sign next to two staircases, and obviously that is not accessible. Some best practices that we recommend is communication. This is really important in terms of understanding what somebody needs, keeping them updated as to what's happening, and following through with them and helping them understand that you're following through, I think is always beneficial to both parties. Even if your update is we've ordered whatever we need, we were just told it was delayed or it's arriving tomorrow instead of Friday, those sorts of things are helpful to people understanding that their needs are being met. We often hear concerns raised as, it's going to impact how everything looks or the aesthetics or the design, or it's going to impact the landscaping. Those generally are not going to be feasible reasons to deny a modification request. You can require that the modification be built in a workmanlike manner and that it be up to local building codes so that it is safe. If for whatever reason the original request is not feasible, then alternatives must be considered. So if a ramp is going to be too steep and it wouldn't pass code standards, then you look at a different entrance or a different style ramp. You keep working on the request and considering those alternatives. We've got a quick poll question here. I will share as to whether or not this is a fair housing issue. There we go. An 80-year-old man tells you he needs sturdy grab bars in his bathroom and shower, but the manager will only allow grab bars attached by suction cups. Is this a fair housing issue? Is this a best practice? And we'll allow about 10 more seconds. There's a lot of agreement on this one. Okay, I'm going to end the poll in the interest of time and share our results here. 88% said yes, this is a fair housing issue. And those of you might remember that we had a case example that we've shared where a gentleman was requesting very sturdy grab bars in order to help him take care of himself and live more independently. And they offered suction cups, and that was not a reasonable alternative or a safe one. Okay, so here we go. Number 14. Got a more detailed scenario here. You receive a request for a reasonable modification for a ramp from a resident who has started to use a wheelchair. Check all of the options here that apply. You can meet with the resident to learn more about their request. You can ask for a letter verifying that he has a disability and disability-related need. You can review the space and compare it with local code to see if a ramp will fit. You suggest that he move to an apartment complex down the road because this one no longer meets his needs. Got a couple of options here. And give you 10 more seconds. Okay. I'll end and share. Okay, so 86% of you said meet with the resident to learn more about their request. That is an option that might be feasible. Um, to get the process started, gather the information, make sure you understand, and 96% review the space and local code to see if a ramp will fit. Absolutely, that makes sense. 41% said ask for a letter verifying that he has a disability and disability-related need. And this goes to one of the questions in the Q&A as well. It really depends. If you have observed him or he comes to the office using the wheelchair, then I would discourage asking for any verification because you can observe and you have now knowledge that this is a disability and disability related need. And I would not ever suggest that an alternative of him moving out until all of your options have been exhausted. So that is not a best practice to go straight to this doesn't meet your needs anymore. And here we have a case example to help illustrate how some of these requests should not be handled. This is a Michigan case. We had a fellow Fair Housing Center contacted by a man with dwarfism, Daniel Black. He settled a lawsuit with the complex that he lived in and the management corporation after 5 years of struggles. He requested his federally subsidized apartment be outfitted with a roll-in shower to accommodate his disability, and he also asked for a replacement because the bathtub was increasingly dangerous for him to use. He essentially had to kind of vault himself over a concrete wall and into the tub and was really exacerbating his current disabilities and causing new damage to his body. He also wanted an accessible electric entrance door so that he and the other residents who were seniors and people with disabilities could come and go without assistance from their accessible apartments. The tub wall was 16 inches tall. His inseam is 17 inches. So there was pretty clear need here, but the housing provider claimed that a roll-in shower would cause structural damage to the building. However, they never provided any documentation of that or proof that it would violate code. They also did not engage in an interactive process with him or offer any alternatives, which is required. The city inspector verified that there would be no structural damage, as have two outside contractors. He did contact the local Fair Housing Center after not getting response based on his own advocacy. The center wrote letters, spoke to staff and the staff's attorney. The local inspector was also brought in, and each request was delayed and denied. And according to Mr. Black, he said it was dangerous. He's already had back surgeries. This is causing extensive pain, and he does have hardware already in his spine that severely limits his mobility. He felt he wasn't seeking anything unreasonable and just wanted what everyone else had. They worked with a cooperating attorney. It was filed in the federal district court here, and according to the lawsuit, the defendants threatened Mr. Black with eviction in order to intimidate him because he sought to exercise his right to have these modifications. Eventually, after all of this, they installed the shower and the electric entrance door. The lawsuit did settle for an undisclosed amount. So the importance of communication and working together illustrated by that case. On the other side, we have accommodations, which I've mentioned before this morning, which are changes to your rules, policies, procedures, or services, if necessary for a person with a disability to have equal access and enjoyment of their housing. We've got visuals here of an access aisle with an accessible parking spot and a curb cut, and assistance animals there on the right. There's all sorts of accommodations that can be requested, and we encourage you, as always, to listen to all requests, whether they're modifications and accommodations, gather the information that you need, and then get to work, because somebody could be requesting an overnight caregiver, an assistance animal, a designated accessible parking spot, accepting rent on a different date based on when disability income arrives for the tenant, and even releasing them from their lease penalty-free if the housing no longer meets their needs based on a disability. Transfers to different floors or units are very common accommodation requests. So these are all examples, but there are many more things that could be requested. Here's a case out of California where a local fair housing center there worked with a property and a tenant because the tenant was trying to get a live-in aid and a key to a locked gate by her unit that would make it much easier for her to come and go freely. The property manager and the owner asked intrusive questions about her disability, questioned whether she had a disability, and asserted the development was for people who could live independently, and then denied her requests. They denied having discriminated against her, but they did enter into an agreement where there was monetary relief, but also that they keep the gate near the residence unit unlocked or provide her with a key, allow her to have the live-in caregiver, and required them to get training and implement reasonable accommodation policies that comply with fair housing law. Another case out of Louisiana, this was a reasonable accommodation request for a transfer. The settlement included training, policy changes, and over $200,000 in damages and fees. Susan McMullen wanted to move into a first floor apartment in 2017 after surgery left her requiring the use of a wheelchair. She was on the second floor and there were only stairs available. She made 3 additional requests over the course of a year and those were all denied. So she was left crawling up and down the stairs or calling 911 anytime she needed to take her trash out, pick up her mail, go to church, go to the doctor, get groceries, etc. The fire district responded to over 100 calls to her apartment, and in fact, the fire chief implored the apartment complex staff to move her to the first floor apartment. Her requests were responded to by placing her at the bottom of the wait list, even though they had at least one ground floor unit vacant and available. So only after the lawsuit was filed did they offer the ground floor unit. This settlement is important because it ensures that people with disabilities are prioritized for those units and applies to all 9 complexes that they own across Southeast Louisiana. Quick question on documentation needed. So we're going to ask you to, if I can get Zoom to launch there, answer questions about what sort of documentation should we request based on, oh, sorry, it's not letting me launch. Bree, you might have to, nope, wait, maybe I got it. There we go. Sorry about that. Okay. We have a new resident asking for their rental due date to be after the first of the month so that they don't have to pay late fees every time their disability income arrives in the middle of the month. Do we need to provide information on the fact that they have a disability? Do they need to provide information on their disability related need? Do they need to provide information on both the disability and their need, or they don't need to provide either disability or disability related need information? And I want to acknowledge these can be tricky because we don't provide a lot of facts. We really want to have you kind of apply your knowledge, but we don't give you all the information so that we don't give away the answers each time. So I'm going to go ahead and stop sharing or end the poll because I'm keeping an eye on the clock here. But you can see that we had a pretty even split that people were asking for information on their disability related need versus saying, they don't need to provide either. And in this situation, they are on disability based income, and that is one of the examples in the joint statement guidance that can help establish that a person is a person with a disability. And what you may want to verify is the date of when the income arrives. But, we would leave that to your discretion. Okay. Go back and do another one here. What should you do? You have a person with a heart condition who requests a reserved parking spot due to not being able to walk long distances. You should have multiple choice options here. You can choose all that you think apply. Our first one is request documentation from a healthcare provider. Our second, tell them they can use the existing handicap spot outside the unit. 3, have them pay for the materials to put up a sign for a reserved spot. Or 4, meet with them to discuss the request. And I'll give you about 30 more seconds. I see one of the questions is about receiving benefits in the middle of the month. And so hopefully that question we just answered clarifies that. If rent is due on the first and their income comes on the middle, that is a reasonable accommodation that they can request. Okay, I'm going to end the poll and share our results. And again, we can tell you're an experienced group. So a person with a heart condition, that's not a disability that you may be able to observe or have knowledge about. So if that is the case, you could request documentation. We discourage telling them to use an existing spot because they have asked for a reserved parking spot for their individual use. So just referring them to an existing spot without reserving it is not a best practice. And we don't charge for accommodations and modifications. So you could certainly meet with them to discuss the request. Absolutely. So the 84% and 68% of you, I think, picked great best practices there. Okay, briefly, we've talked about assistance animals. This is an accommodation request that is, in addition to service dogs, includes emotional support animals. These are rights upheld under the Fair Housing Act in Section 504, which applies to federally financed locations and housing. So in situations where both laws apply, housing providers must meet the broader standards between the two in deciding whether to grant reasonable accommodation requests. So those of you with federal financial assistance have the responsibility to do more to meet the needs of people with disabilities, and we can always provide you that information if you need it. So species other than dogs with or without training and animals that provide emotional support have been recognized as necessary assistance animals under both the Federal Fair Housing Act and Section 504. Some provisions here, individuals with disabilities are entitled to, or may be entitled to keep an animal as an accommodation in housing facilities that otherwise impose restrictions or prohibitions on animals. In order to qualify for an accommodation, the assistance animal must be necessary, as with all accommodation requests. And again, very similarly, there must be a relationship or a nexus between the individual's disability and the assistance animal. If those first two requirements are met, then they must permit the assistance animal as an accommodation unless it can be demonstrated that it is an undue financial or administrative burden, or it would fundamentally alter or change the nature of the housing program or services. So those are the only two bases allowed for denial of accommodation requests, including assistance animals. Specific to assistance animals, if the specific animal in question poses a direct threat to the health and safety of others that can't be reduced or eliminated by any reasonable accommodation steps, or if they would cause substantial physical damage. Again, it has to be that specific animal that may be a reason for it no longer to be reasonable to have that assistance animal. Some examples from the HUD and Department of DOJ statements on reasonable accommodations. If you have a no pet policy and a tenant who is deaf requests the provider to allow him to keep a dog that alerts him to sounds like knocks on the door, the phone, cars coming and going, smoke detectors as a result of his disability, they say this is an example of when a housing provider must allow for an exception to its no pets policy and accommodate this tenant. Another example here is an applicant who has a hearing impairment who needs an assistance animal as an accommodation. The housing provider cannot require the applicant to pay a fee or security deposit as a condition of allowing this assistance animal. However, if an assistance animal causes damage to the unit or common areas, the housing provider can charge for the cost of repairing the tenant if that is your normal practice. If you normally charge tenants for any damage caused, then if the assistance animal causes damage, you could charge that. A rental applicant who uses a wheelchair advises his landlord that he wishes to keep an assistance dog, even though, again, there's a no pet policy. The disability is readily apparent, but the need for the assistance animal is not obvious to the provider. So kind of circling back to that question we were just asking, you verify disability, disability-related need, both, or you don't need any documentation. In this circumstance, they say because we don't know about the disability-related need, you can ask for disability-related need substantiation or verification about the assistance dog. Some best practices, you do want to make determinations quickly, promptly. You should only seek information that's necessary to evaluate if the assistance animal is needed due to that disability. You cannot require fees or deposits as a condition of allowing assistance animals. And again, you can charge damages if it's your usual practice to charge damages. Got another poll here for a true and false. This one. Couple questions here. Short ones. A housing provider cannot require a tenant to get renter's insurance just because they have an assistance animal. And number two, a tenant is not required to pay any fees on the front end for an assistance animal. I'm thinking there's a lot of questions in the Q&A, so I'll do my best to get back to those. We'll give about 10 more seconds here. All right. So our first one, a housing provider cannot require a tenant to get renter's insurance just because they have an assistance animal. So that would be treating them differently because of the presence of an assistance animal. So that is true. Our second one, a tenant is not required to pay any fees on the front end for an assistance animal. 92% of you said that is true, and that is true. Any sort of preemptive fees for any disability related need are a red flag under fair housing. If you have questions about that specifically, you're welcome to reach out to us. But in general, costs related to a disability, especially for accommodations, cannot be passed on to the individual. Sorry, I wasn't sharing the results there, but you can see there was a lot of agreement on those two questions. All right. Another common question that we get, or just challenges that some of the housing providers that we work with have encountered, is what if the person requesting the assistance animal provides me with an ID, a card that doesn't answer the questions I'm allowed to ask, or they won't engage in the process, or they tell me they can't be asked any more questions? Well, we encourage you to refer those folks to our website, to your local Fair Housing Center or our Fair Housing Center of West Michigan. Our intake coordinator is happy to provide them with information on what their rights are. We have guidebooks, as many of you know, and you've received in the past, that can help someone making a request for an accommodation or modification, or making a request for an assistance animal. They can follow the guidance that we have for them. And then we have guidance for you as rental professionals as to how you can process these requests. But we do often encounter people who have found information online that is not correct or it's confusing. And so we are certainly aware of that, and we are happy to tell people that you're trying to work with how they need to engage in the question and answers that you need to embark on together. So hopefully that is helpful. Before I turn it over to you, Bree, I think we can both maybe try to take a stab at some of the questions that we've had coming in. That's okay. Kind of going back to the top of the list here, and feel free to chime in. I'm keeping an eye on the clock. But if you have a handicap accessible unit available, are you allowed to ask the applicant if they require a wheelchair or walker? And I would discourage collecting any of that type of information. I think I saw another question about having questions on the application. We really encourage you separate those types of questions, and that you don't ask for disability related information until someone has identified a need to you for an accommodation or a modification. Then you can engage in the conversation, very limited conversation, about verifying, are they a person with a disability and what is their disability related need. So if someone is seeking to rent the accessible unit, you don't have to hold that unit for them in general. And so it's best not to make those types of inquiries. So hopefully that was helpful. We have a question about medical information when it comes to verifying an applicant's disability. This kind of came before the section, so we might have answered this, but if the disability is not known to you already or not observable, then you want to evaluate, what limited information do you need? So our first question for you is always to say, what do we already know? And then what do we need to know? And those are hopefully helpful questions to determine what limited information you can request in order to evaluate an accommodation or modification. If we are not a senior complex or assisted living, do we have to accommodate a ramp at our expense on a building for a resident that is now in a wheelchair? That would mean we could be financially responsible for any ramps should this happen in another building. Great question. So we have more questions for your question. And part of that is, do you have federal funding But if somebody does need a ramp that the public and other residents would use, generally the responsibility would be on the housing provider. If it's a ramp for their individual use and there's no federal money at the property, then the person likely would pay. But it depends on those facts. So that would need to be evaluated on a case by case basis. Um, an accommodation be a disability parking sticker for a part-time caregiver. We would need more information about that if the caregiver is driving the person with the disability. That may be substantiated, but generally, we would need more information on that question. Um, If someone is seeking to have a number of animals that is not in compliance with local law, they do need to consult with the local government in order to make an accommodation request to them. Um, Applicants who might be requesting a translator, that depends on how you're funded, and what sort of conversation is being had. If it's related to like signing the lease and things like that, it would always be beneficial. It's always a good idea to know what local resources are for translation. If someone wants to see a model, am I required by law to ask for ID and what that should be? I think we would need maybe to see your policy on showing units, and then we could provide some fair housing information specific to your policy. Okay, so I'll try to keep answering these, Bree. They're coming in fast and furious, but I want you to be able to finish this last section really quick. So I'll try to take over typing responses and give it over to you.
Perfect. Thank you. Yes, I've been trying to answer some folks' responses as well. So
Great
there is
questions.
a lot of questions. We have open 14 questions. So please be patient with us. You can also email us afterwards if we did not get to your question, because there are some anonymous ones in there. Okay. So we have poll 18 here. These are going to be some true and false questions. Under fair housing law, a person can be held liable for a violation even if they did not intend to violate the law. True or false? If families with teenage kids have caused physical damage to your apartments in the past, it is okay to require an extra damage deposit from families with teenagers. True or false? Maintenance staff are required to offer a reasonable modification based upon a disability, even if no request has been made. True or false? Oh, did I end the poll? I am so sorry about that, everyone. I don't know what happened. Okay, sorry about that. I missed. Sorry. So now you can answer them. Yes, sorry about that. I was also confused why no one was answering. So the first one, a person can be held liable even if they did not intend to violate. Uh, it's okay to require an extra damage deposit for families with teenagers, and maintenance staff are required to offer modifications based upon disability even if no request has been made. Give about 20 more seconds here so we can make sure we have enough time for things. Alrighty. Share the results here. And I agree with 96% of you. Even if you do not intend to violate the law, you can still be held liable. That's why it's important to get the trainings and things and such, just so you make sure that you are aware of the law. For the okay to require an extra damage deposit, I would agree with 95% of you. That is not okay. So that would be a difference in treatment in terms policies. You're requiring families with children to give you an extra damage deposit. Maintenance staff are required to offer reasonable modification even if no request has been made. So that would be false. Yes, false. You're not required to offer reasonable modifications, even if a request has been made. So you only have to offer them if a request has been made. Great job there. Next slide, please. Just going to be another poll. So, which of the following groups must comply with fair housing laws? Choose all that apply. Property owners, condo association board members, contracted staff, landscaping, pest control, etc., managers, maintenance team, residents, and none of the above. About 15 to 20 seconds on this one. Okie dokie. I'm going to end that poll here. Do, do, do. Share the results. The answer is everyone. It's all of them. Everybody that is associated with the property must comply with fair housing laws, and that does include residents. It does include contracted staff because you are contracting that staff, those people out. Yeah, so everyone must comply with fair housing laws. A little tricky of a question there. And then we have one more, I believe. Yes, this is a what should you do? You go to the next slide, please, Liz. Several weeks ago, maintenance orders were submitted by 3 Burmese tenants. You notice that more recent orders submitted by white tenants were addressed instead. The repair orders for the Burmese tenants appear to have been ignored. What do you do? Talk to the staff to learn more, provide training about equal treatment, depends on the types of repairs, and there is no fair housing risk here. Give about 10 more seconds because we are coming up on 11 o'clock here, and I want to make sure there are no questions that we want to answer verbally. Everyone is great.
I also want to highlight that the evaluation link is in the chat, so please be sure to copy or click on that before you leave.
Thanks, Liz. Yep.
Mhm.
So ended that poll there. Yes, talk to the staff to learn more, provide training about equal treatment, and also part of talking about talking to the staff would be maybe what types of repairs were they. But if they've been ignored, that may not depend on the types of repairs. They're being ignored. So it depends on what information you have. Alrighty. So Liz, next slide, please.
Okay, so can I just jump into before we leave kind of the Q&A and information? So as we mentioned at the beginning, HUD is reviewing a lot of guidance, and that does include the assistance animal guidance. So we are relying on the joint statement for reasonable accommodations and encourage you to check that out. It's available on our website. And so, we understand you have a lot of questions, and we will also have a lot of questions. So we're kind of giving you best practices that have been to date, but we'll keep an eye out for any further guidance or changes from HUD and push those out to everybody.
Thanks, Liz. So we have some Mishta links here that are available on the handout. So make sure you download that by the end of today so you get those. Next slide. Our tools and resources. We have lots of publications, brochures, studies, guidebooks, things like that on our website. So check that out. We have a event on October 23rd at 9 a.m. It's our 19th annual Lakeshore Friends of Fair Housing event where we'll be talking about source of income. Heather Abram will be coming and talking about source of income protections and cases. You can register that with that online. That link does take you to register for that, and that will be on Zoom. And then just a little blast, if you really love this work and love what we do, please show your support and become a member today. It's how we can provide, do these things, offer these services that we can, otherwise we have to do things that are just directly contracted. So there's a link to become a member there. And then that is it. So thank you so much, and we'll answer some questions. The link, the SurveyMonkey link is the link to utilize. That should also be open in your browser. Please make sure you complete that fully with your first and last name, the correct address. Make sure it's the address that it should be going to. We will only send it once, otherwise then it will come via email if it does not come in the mail. So please make sure that the address is correct. That has to be completed by tomorrow at 5 p.m. please make sure you do that. Otherwise, we cannot verify that you attended and cannot provide a certificate. Please allow us like a month to get those out to you as well. If you have any questions, feel free to put them in the chat. We'll stay on for a couple more minutes, but otherwise you are welcome to head out if you have no questions or you need anything else from us. So have a wonderful day, everyone. Thank you.
Yes, and Lindsay put the registration link for the October webinar in the chat, so it's also on our homepage. So please feel free to join us for that great free event. And we will get training information out as soon as we can.